Senator John Kennedy opened a tense round of questioning during a judicial confirmation hearing, pressing multiple nominees on foundational constitutional principles. Senator Kennedy began with Judge Dudik, immediately challenging her understanding of the Fourth Amendment's warrant requirement.
What's the warrant requirement?
Well, before the court would issue a warrant, you have to assess to make sure that there's probable cause to either search the place.
When's a warrant required?
Excuse me?
When is a warrant required?
The general rule is a warrant is required anytime that the government wants to search a person, place, or thing.
Could you speak into the mic?
Oh, I'm sorry, Senator. Yeah, I said the backdrop rule is that a warrant is required anytime the government wants to search a person, place, or a thing.
And to arrest you, right?
There are some exceptions to that, but generally, yes.
Okay. And there are exceptions to the warrant requirement for searching and arresting people, are they not? Are there not?
Yes, Senator, there are.
Okay. Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. Mm-hmm. No exceptions. Can the Florida Supreme Court do that?
Well, Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it.
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
Well, they would still, Senator, have to apply with what the federal Constitution said.
No, they wouldn't.
Under the Supremacy Clause.
Do you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they.
No, they don't. As long as you don't take away rights, but add to them, a state can do whatever it wants to under its state constitution, can it?
Yes, sir. Yes,
Senator. That's not what you just said. You think the Supremacy Clause applies? The Supremacy Clause applies.
Well,
you want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature or Florida could do exactly what you said. I meant in my statement is that.
Trust me, it can. Judge Pruitt, I'm sorry, I can't see that far.
It's Judge Pratt, Senator. Yes.
Judge Pratt, I apologize. I can't see that far. Can a state legislature pass a law that discriminates against a group of people over another group of people for inferior treatment?
Well, Senator, the federal Constitution and the state Constitution both contain protections against various forms of discrimination.
But can a state legislature say we're going to treat this group of people differently than another group of people?
So I think, Senator, an example where a legislature
could.
Tell
me first if a state can do that.
Yes, a state can, for example, require a driving age which discriminates on the basis of age. To say, for example,
when can a state legislature not do that?
When it's seeking to do so under a basis that is protected under the state or federal Constitution.
Okay, good. Judge, tell me about the privileges and immunities clause.
The Privileges and Immunities Clause, there's a privileges and immunities and a privileges or immunities clause. There's one of each. One of them relates.
Privileges and is what I'm asking you about.
I believe you're referring to what came through in one of the Reconstruction amendments and discussing the fact that that the privileges and immunities of citizenship would be extended under those.
First, what article is it in?
I believe it's in the 13th Amendment.
No, 4th. Article 4. What does it do?
Senator, you have pinpointed a question that in my 9 years as a judge, in my decade of private practice before this, my 2 years as a law clerk, my 2 years on law review in law school, including a year as editor-in-chief, didn't ever come up.
You tell me you don't know?
So it's an interesting question.
Yes,
and
ma'am. I know it's interesting. That's why I asked it.
Yes,
but you don't know the answer. Just tell me. I got a lot of ground to cover here.
I would be very happy to research it.
Okay. Do you know what the privileges or immunities clause is?
With respect to my answer would be the same on that.
You don't know it either.
Well, with respect to the privileges and immunities of citizenship, my recollection is that
Privileges are immunities.
yes, my recollection is that was discussed in one of the Reconstruction amendments.
Which one do you know?
I believe it was the 13th or the 14th.
Okay. All right, Judge. What's Title VI of the Civil Rights Act of '64 do? Ma'am?
Which judge?
This judge down here on the far end.
Artau?
I can't see that
Okay.
far.
Just making sure, because there's 4 judges there. Judge Artau, I'm going to let you answer that briefly.
Hey, I want to reclaim my time, Mr. Chairman.
You can
Madam
answer that
Chairman.
briefly.
Judge, what's Title VI of the Civil Rights Act do?
I believe that ensures that people are treated equally in any places that they would be, that they would not be discriminated against.
In all cases?
Refresh my recollection as to what you were referring to,
I'm
Senator.
referring to Title VI of the Civil Rights Act of 1964, which you're going to see every other Thursday as a federal judge.
So I believe that's under the Commerce Clause. They wanted to make sure that there was not any discrimination going on with regard to race, and that was addressing
it. It prohibits discriminating on the basis of race or color or national origin under what circumstance? Do you know the answer?
Under any circumstances where you're providing services to people.
No, it's only if you're getting federal money. You need to brush up on that one. I'm way over my time. Thank you, Madam Chair.
Thank you, Senator Kennedy. Senator.
When asked to explain when a warrant is required, the judge noted that the government generally must obtain one before searching a person, place, or item, though she acknowledged exceptions. Kennedy then posed a hypothetical. What if the Florida Supreme Court ruled that there are no exceptions at all, that every search and arrest must always require a warrant? Judge Dudik suggested the Supremacy Clause would prevent such a rule, but Kennedy pushed back sharply, arguing that states may expand constitutional protections so long as they don't take any away. After the exchange grew tense, the judge revised her answer, agreeing that Florida could, in fact, impose stricter rules under its own constitution. The senator then turned to Judge Pratt, shifting to the question of whether a state legislature can pass laws treating one group of people differently from another. Judge Pratt acknowledged that legislatures can create certain distinctions, such as age requirements for driving, but cannot discriminate based on constitutionally protected categories. Next, Senator Kennedy asked Judge Pratt to explain the Privileges and Immunities Clause under Article 4. The judge struggled to pinpoint its location and purpose, noting that the issue had never arisen in her years of legal practice. Kennedy pressed her again, prompting the judge to admit she would need to research the answer. Finally, Kennedy directed a question to Judge Artau. What does Title VI of the Civil Rights Act of 1964 do? The judge responded hesitantly, noting that the law prohibits discrimination based on race or national origin. But the senator quickly corrected him, emphasizing that Title VI applies specifically to programs or institutions receiving federal funding, a detail he said every federal judge must know. Running out of time, Senator Kennedy concluded his questioning, leaving a pointed reminder: these federal protections and constitutional provisions will appear frequently on the bench.